What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.
Welcome to another edition of Legal Briefs. This is an educational program produced by our law firm, BBKCC Attorneys, in partnership with WCTV as a community service. My name is Rick Boston. I'm the managing partner of BBKCC, and it is my pleasure to host this segment today, which is focused on powers of attorney. We chose this topic because we regularly get questions probably every day from clients about powers of attorney, and probably other than deeds, it's the single most popular document or most prepared document that we use in the office. But most importantly, it serves a critical component in anyone's estate plan. So joining me today is one of my longtime law partners, Doug Oler. Welcome, Doug.
Thank you, Rick.
So
it's nice to be with you.
We don't have a whole lot of time, so let's delve right into our topic and begin talking about powers of attorney. First of all, what is a power of attorney? I think that's the place to start.
Power of attorney is a legal document that allows you to appoint another person to make decisions for you if you should become temporarily or permanently unable to make those decisions. In other words, it's a document that allows you to plan ahead in anticipating incapacity.
Okay, and why are powers of attorney so important, or why do you think someone needs to have a power of attorney?
Power of attorneys are becoming more and more important in today's world because as a society we're living longer. As we live longer, the odds increase that you may incur dementia of some sort. As you increase those odds of incurring dementia, you may be no longer able to make decisions for yourself. This gives you an opportunity to make the plans to have somebody else make those decisions for you. Good example is bringing it home in my family, my mother situation. She lived till she was 95. The last 5 years of her life were in a retirement home, and she was incapacitated during that period of time. If I'd not had a power of attorney, I could not have sold her house prior to her entering the retirement home or made medical health care decisions for her. So it was extremely necessary to have a document such as a power of attorney to be able to handle her affairs.
And just maybe briefly, if you don't have a power of attorney, then normally you end up having to go to court and have a guardian appointed, and then you get the courts involved in supervising it and biannual accountings to the court. And if you need, to purchase items for the person, if new TV for their room or anything like that, you've got to get court approval. So it's much easier, I find, that if you can go with a power of attorney and hopefully avoid the court's involvement in the family affairs and keep it.
Right. I usually use the guardianship as a last resort.
Okay.
Because of those reasons.
And are there different kinds of powers of attorney?
Yes, there are. In Indiana, we have basically two power of attorneys. One called a general durable power of attorney that's used for business and financial affairs. The other power of attorney is a healthcare power of attorney that we use to give authority to someone to make healthcare decisions. In addition, you can have limited power of attorneys that are used for a specific purpose, a limited purpose. such as if you wanted to give somebody authority to just sell your house while you're gone, for example, then you could give them a limited power of attorney to perform that service only. But basically, there's two power of attorneys, the general durable and the health care.
And in looking at those two types of powers of attorney, I guess it's always been kind of my feeling that I do them as two separate documents. And I don't know how you feel about that, but I guess I always feel like with the power of attorney or the healthcare power of attorney that those have to be supplied in a lot of cases to hospitals, attending physicians, various people like that, which the general durable power of attorney, which relates to business affairs, as you indicated, really has, I mean, that's kind of a private matter that you really don't want to make public, and
Right.
you don't want that just floating around. So I think it's probably wise to do two different
I agree. I use two different
documents.
separate documents.
Okay. And as far as, are there certain basics that are required when you draft a power of attorney, or what should you include in a power of attorney?
Yeah, I guess maybe this is the place to say that there is a statute, Indiana statute, on power of attorneys that deals specifically with power of attorneys. And in that statute, it sets forth the requirements of a valid power of attorney. And there's 7 or 8 items there. I wish we could put them on the screen, but let me go through them real quick. Number one, it has to be in writing. You have to identify who the principal is, the principal being the party who is giving the power, and identify the agent. That means you have to identify who you're giving the power to. Then there needs to be a statement of when that authority starts. When does it become effective? You then have to state what powers you're giving, because if you don't give certain powers, then they don't have those powers to act on your behalf. It has to be notarized, not witnessed, but notarized. It has to be delivered to the agent. And there has to be some sort of a preparation statement at the bottom so that suitable for recording. Those are the basics that are required to have that valid power of attorney. This may be a place, Rick, where we discuss how many, when we're talking about one of the things that you have to have is spell out who the agent is. You may want to real quickly talk about how many agents can you have. Can
Sure,
it be
sure.
1 or 2 or 3?
Right. That's always a question. I mean, people ask. Normally, a lot of times, people will appoint their spouse as the principal attorney, in fact, to handle their affairs. But if there's a successor, children involved, sometimes people ask, well, can both of my children be powers of attorney, or 3 children, or whatever? So I think if you want to discuss that a little bit about the pros and cons of using multiple powers of attorney. And
Well, the short answer is yes, you can have multiple agents. You can name, if you have 3 kids, all 3 of them. Is it wise to do so? That's another matter. But legally, you can have more than 1 agent. I do not usually recommend more than 2, but legally you can go to 3 or multiple. If there are multiple agents named, you then get into the issue of how do they act in relationship to each other. Can they act separately, or do they have to act jointly? And as you know, the law says that if there are multiple agents and you do not spell out a priority, then the law presumes that they have to act jointly, meaning they have to consent for each act to be accomplished. If you just name 1, then each party can act or if you want to spell it out, each party can act independently. In other words, you can have 2 agents and say that they can act independently of each other. That gets a little awkward for a third party that's looking at that power of attorney and wanting to know who really has the authority.
Right, right. Well, and I think another thing, once people realize if they say they have two children, they'd like both of them to be the agents on this, when you tell them that if it's going to require both their signatures and you've got one child that lives in California and one lives here in Indiana, and, you know, every check that you write for your parent or whoever has to be co-signed by both of them, they quickly realize that that's not a workable alternative, and usually just elect to go with authorizing one of them or either one of them to act individually, so that it doesn't require.
We have to remember the key thing is we have the ability to point who our agent's going to be, and then we have the ability to say if you want multiple agents, how do they have to interact?
Right. Yeah. Right. Well, now that we know, you know, what a power of attorney is and why it's important to have one, are there still other important decisions that a person has to consider in meeting with the attorney to draft the power of attorney?
There certainly is. Probably the two key decisions, and maybe the one that comes first and is extremely important, is the mental capacity of the principal who is wanting to give the authority to somebody else. In fact, it's probably the most important decision we face as attorneys in knowing whether to prepare that power of attorney for someone or not. Be interesting. A typical example that happens to me and probably happens to you several times too is you get a call from a son or a daughter saying that their mother or father's in the hospital and they need a power of attorney quickly so that the kids can do certain things. And the son says, Mom and Dad want to give me the authority, or they want to give somebody else the authority. And the first question that comes to my mind in that example is Mom or Dad competent to make that decision? He says, yes, they have good days and bad days, or they have good mornings and bad afternoons, or sundowners, or something like that. It's never black and white. It's usually a gray answer that you're getting. So you're faced with, do you proceed with that, preparing that power of attorney or not? It means that I have to meet with them usually to evaluate them myself so that I get a feel for whether he or she are really competent to make these decisions. If I'm still uncertain, I then say we have to have a medical opinion from the family doctor or from some specialist, a neurologist or something like that, because we're not medical doctors, and I don't want to be making that decision as to whether somebody's competent or not. It's really, really tough. Many times it's gray as to whether they can make that decision. I'm sure, run across that many times.
And I think you have to evaluate the family situation. I mean, if there's two children and they're both there and they both feel like their parents competent, and you kind of maybe know the history of the family and so forth, you maybe feel a little bit more comfortable after you talk to the person of saying, I think, they know what they're doing, and where if you're just called and you don't know the person at all and you go to the hospital or a nursing home, and then you've got to evaluate somebody that this may be your first encounter with, and trying to assess whether the answers they're giving are what would be normal for them. And
we have to remember as attorneys, we ethically have a responsibility. We cannot allow a client to sign a document that they do not understand what the nature is of it, to understand what they're signing. We then ethically can't permit that to occur. So it's extremely important to get a handle on the mental competency. And many times, you don't always get a straight answer from the family.
Right, because they've got kind of a vested interest at that point of knowing they don't want a guardian appointed, and they want to try to, it's Mom or Dad's waited too long really to do this, and now they want you to come in.
And you're always in the back of your mind wondering if you get a call from a son that says, Mom, Dad want to give me the the authority. Is there a sister or another brother sitting there thinking the same thing? And
Yeah.
so it's a tough.
Because I think both of us and all the attorneys in our office have had situations where, and been, whether we've had them personally, aware of situations where, somebody's been appointed and they've kind of cleaned mom or dad or whoever it is out, because they have full control of the bank accounts and that type of thing, selling real estate, whatever, and then all of a sudden when the other kids realize what's happened, there's nothing left.
That gets into the second, kind of segues into the second decision.
Selecting an agent and
Selecting an agent, yeah. You have to be, the next important thing is making a determination of who you want to make those decisions on your behalf. You want that person to be responsible and trustworthy and hopefully make similar decisions to what you make. And so that selection of that agent is extremely important. Too often, I think, mom and dad will just name the oldest child, and may or may not be the right decision.
Right.
Probably the best example through the years of selection of an agent is the old Groucho Marx. We may be the only two that remember Groucho Marx, but as he grew older, he had to have several caretakers, and he had never married, had no children, and so he would appoint a caretaker, and as he went through the caretakers, he would name the new caretaker, and when he died, he had practically been bankrupt from the caretakers doing things that they shouldn't have been doing. So it's really important to give that some serious consideration first.
Sure. Well, and besides just the agent, you can also, as if you're named as the agent, and we refer to these as attorneys in fact, and that doesn't have anything to do with being an attorney at law. That's just another name that's used for the agent that's named by the principal. You can hire other experts, whether it's, investment advisors, attorneys, accountants, or whatever, to assist you in helping make decisions and in handling the
In fact, I always tell the principal that they don't have to know everything in the world, but they need to have enough moxie to know who to go to. What you really want is to make sure they're trustworthy and reliable, and if they are, they're going to have the ability to go find legal help that may be needed, tax help that may be needed, or accounting help that may be needed. And that's the type of person you're looking for, I think.
Right. Well, and I think, again, we talked a little bit about a guardian, and hopefully you don't, with the power of attorney, you don't get to the point where you do need one, but I think, that's something you can name in your power of attorney. You can name who you would choose if you had to have a guardian, and if it gets to that point, and I think, normally, you can comment on your experience with the courts, but I tend to think that the courts will follow those wishes unless the person's just not competent to handle the
I find that
responsibilities.
To be true. But maybe this is a good place, though, to talk about why we recommend power of attorneys first before guardianships.
Sure.
And let me just take a minute and say what a guardianship involves real quickly. It's a court process. A power of attorney is just a document that we prepare and they sign, but a guardianship involves a court process. You have to petition the court to declare somebody incapacitated, and then ask the court to make that determination, and then ask the court to determine who is the proper person to be guardian. That process takes time, and time is money. So we typically use guardianships as a last resort when there's no power of attorney and you have to go that route. And as a result of, this will get into one of the last areas, is because of time is money, then it takes less time to do a power of attorney. It's cheaper than a guardianship.
Sure.
So those are the reasons why we hold off on guardianships till the very last.
Right. And if you do elect to do a power of attorney, are they revocable? I mean, if you decide you want to change your mind, you want to revoke the power of attorney completely, you want to do a new one, you want to name somebody totally different than you did on the original power of attorney?
The short answer is yes, they are revocable. You have to remember that if you revoke them, they have to be revoked like they are signed. In other words, you need to have a written revocation. It's not a complicated document. It's a 2 or 3 sentence saying, I hereby revoke the power of attorney I signed on such and such a date. And then you should give it to everybody that you've given the power to, who is relying on that. For example, if you've given the power of attorney to the bank, and you're going to revoke that power of attorney, and you need to give a copy to the bank, for example. So yes, they are revocable, but they need to be revoked in writing.
And once you execute your power of attorney, what do you advise your clients to do with the original? And I guess we should mention that in most cases, copies can be used with handing out the power of attorney with if you need to take a copy to the bank or whatever. But in terms of do you share that power of attorney with the agent that you've named? Do you who keeps the original? What's your suggestions on that?
Good question. And maybe every attorney's practice is a little different than this. What I do is I have them sign 3 originals. I keep 1 original in our file, and I give 2 originals back to the principal. And with the thought that if they want, they can give that additional original to their son or daughter, whoever has the power of attorney, so that they've got 1 also in hand. That's as I said, you may handle that differently. That's how I do mine. But basically, I keep 1 and give 2 back to the principal, with the kind of the directions that they should make the agent certainly aware that they have prepared 1, and if you don't give them 1, to tell them where they can be found, because power of attorneys can come up the need for the power of attorney can come up in a hurry. If you're in a car accident, for example, or have a stroke, somebody perhaps needs to get a hold of that power of attorney and act immediately. So it's very important that agent knows that you have 1 and knows where they can be found.
And with your suggestion of, of car accident or something, I think, again, this is where I think a lot of people consider that they don't need a power of attorney until they get to the point of retirement age or are thinking in those terms, where I think younger people, it's just as important, because you don't know when you're going to be in some kind of an accident or whatever and not able to take care of your affairs and business for an extended period of time, or you're even people that travel and out of the country and that type of thing, of leaving the authority with somebody to make pay bills and take care of affairs while you're either incapacitated or while you're out of the country and not able to do so. And
that's right. This may be a good time to bring up the famous Florida case, the Shivo case.
Mm-hmm.
That was a 24-year-old married girl that was in a car accident. She lived in a coma for 8 years, unresponsive. She had that 24-year-old, generally, the last thing on their mind is doing power of attorneys. But that became a very difficult case, very difficult time, because she did not have power of attorneys.
Sure. Well, and there's, as far as when you need to review your power of attorney and maybe update it and so forth, there have been some changes. I mean, you might mention 2 or 3 of those that people that may already have a power of attorney might not be aware of, and they might want to review their power of attorney in light of that and think about updating it.
Sure. As I stated at the beginning, there are certain things that have to be in that power of attorney, and the powers have to be listed. And so over the last few years, they've added additional powers. HIPAA being one of the big ones, as you know, the old privacy rules that you couldn't get medical records, for example. You now can put in the power of attorney that you're giving authority for that agent to have access to your medical records. That's one. And the second one is you now can do TODs with deeds with power of attorneys. And lastly are the old digital asset.
Right.
Not old, it's new.
That's probably one of the big ones.
Right.
I mean, there's been so much with digital assets and passwords and that kind of thing that I think that everybody probably needs to consider that in their powers of attorney and their wills and so forth, so that personal representative or agent or whatever has access to those. And I guess we're almost out of time here. One thing that's kind of related that probably is maybe a good topic for later is a funeral planning declaration. It's not a power of attorney, but again, there's a specific Indiana code section on that, and I think that both of us would suggest that our clients consider executing such a document. You can provide for, the funeral, for, whether you want cremation, burial, casket, funeral director, all that kind of thing, and it's all kind of a form document.
Yeah.
That,
I think real quick, we forgot to mention that power of attorneys end at death.
right, they do.
But one of the exceptions is what you just mentioned, the ability to make burial and funeral arrangements.
Sure. Okay. Well, I think maybe that's a good place to end our discussion. We could go on for quite a while, but I think we're pretty near the end of time. The only thing I would like to suggest to all our viewers, if you have topics that you would like to see us discuss on future segments of Legal Briefs, don't hesitate to contact us. Contact us through our website, bbkcc.com. That's bbkcc.com, the initials of the law firm. And there's an email form on there, and you can just drop us an email and give us suggestions of topics that you might like to have discussed, and we'll be happy to consider doing so. So thank you to everyone, and hope you enjoyed the program.
What is discussed on this program is meant to be for general information and educational purposes. It is not intended to be legal advice and should not be used for that purpose. If you have legal matters you need help with, then you need to seek the advice of an attorney.